All right, good afternoon, everyone. My name is Devin Robinson. I'm the Deputy Director of the Office of Outreach, Prevention, and Support here at the Justice Center. Welcome to the second session of our 2023 Justice Center Summit on the overview of pre-employment checks. Before we get started, we're just going to do some Zoom housekeeping for everybody. So this session is a webinar and all participants are muted and off camera. Please look at the control bar. If you're not familiar with Zoom, it's at the bottom of your screen. Take a look at the icons. If you don't see the control bar, just scroll your mouse near the bottom of the page and they will appear. We will be taking questions through the chat function of Zoom. So if you have a question, you can put a question in the chat. We will also be posting helpful information in the chat during the webinar with links and other items that might be helpful. And so when you ask your questions in the chat, if they are related to pre-employment checks, we will ask them. We'll take breaks at each section to try and get those questions answered for you. If we don't answer all of your questions, there's contact information at the end of this, and you can certainly contact us again. To view closed captioning or live transcription during the meeting, you can click on the closed caption icon that you see here on the screen, and that is also at the bottom. And you click closed caption to stop doing that. So with that, I will say happy Zooming, and it is my pleasure to introduce today's presenters, Deirdre Keating and James Buccini, to talk about pre-employment checks. Take it away.
Great. Thank you so much, Davin. Thanks everybody for being here and learning and listening about pre-employment checks. Jim Buccini and I have been with the Justice Center since basically before it opened, so we've probably spoken to a lot of you in the audience, and we'll be happy to go through and answer any questions that you might have. So the PowerPoint is coming. Here it is. Thank you, Lisa. So today we're going to do an overview of the Justice Center pre-employment checks and the requirements. I'm going to speak about the staff exclusion list, and then we're going to turn it over to Jim, and he's going to talk about the criminal background checks determinations and some of the authorized persons' responsibilities as they relate to criminal background checks. So on our website, when you scroll down, you'll see pre-employment checks, and it's broken into staff exclusion list and criminal background checks, and they're very helpful and has a lot of guidance on there. There are other required pre-employment checks that are not processed by the Justice Center. A lot of providers have to also do statewide central registry checks with OCFS for child abuse and maltreatment. And OPWDD providers have to also do the Mental Hygiene Law 1634 check, and that's completed by OPWDD. So we're not going to be talking about them today, but just to be aware that they are out there. So staff exclusion list checks. Here's a graph of the number of staff exclusion list checks that we get by month. I've averaged out, it's about 27,000 per month and over 300,000 a year that we process here at the Justice Center. Most of them are done instantaneously, and the authorized person gets a response immediately. If there's a potential match, the response will be within one business day. Since 2014, the Justice Center has advised 272 potential employers and providers out there of an individual's placement or pending placement on the staff exclusion list. That means they were considering hiring somebody who was on the staff exclusion list or pending placement, and when they did the staff exclusion list check, we advised them of that. In 2022, 54 individuals were placed on this list and 24 were removed on the staff exclusion list. And just for purposes of big picture, the total number of subjects on the staff exclusion list or pending placement on the SEL as of March 1st of 2023 was 881 people. So some other staff exclusion list data. If an individual does not have a social security number, we have a manual process check, and those average about 96 checks per month that we do that are done manually. And when the staff exclusion list check response is returned, OPWDD providers also get notice if their applicant has a final Category 2 finding. And if you're familiar or have ever seen one of these responses, or if it's a pending placement, or if the person has a Category 2, the applicant, the provider can request additional information about what conduct was involved in the Category 2 finding or the one that resulted in a pending staff exclusion list placement. And between August of 2015 and December of last year, we had over 700 requests for additional information, and those are basically for Category 2 people that were applying with OPWDD providers. And every week we do a manual double check to make sure that providers have done the staff exclusion list check before sending somebody for fingerprinting, because obviously if somebody is on the staff exclusion list, for most providers, they would be unable to hire them, and there would be no reason to send them for criminal background check. So our weekly manual double checks in 2022 indicated about 20 times where a provider, an authorized person of a provider, forgot to submit the SEL check prior to sending somebody for fingerprinting. So we reach out to them and say, please submit that check, and to find out the current status. Some numbers on the criminal background check realm for 2022. You'll see there's been over 100,000 criminal fingerprints taken for part of the Criminal Justice Center's checks. And those numbers, I believe, remain relatively steady over year by year, right, Jim?
That's correct.
Right. So, and you can see out of 100,000 fingerprints, there's 11,000 that had some sort of criminal history that needed to be reviewed. So 89,000 go through clear without any sort of intervention whatsoever. But if an individual has a criminal history, the criminal background check unit takes a look at it, and we request additional information pursuant to the correction law at times. And Jim will go through this much more in detail during his portion of the presentation, but that's just an idea of the numbers that are done for criminal background checks by the Justice Center. So we're going to go through some of the requirements.
Sorry, there's a couple questions that came through. So the first one is, this is very technical. I'm not sure that this is appropriate for the Justice Center, but you guys will know. Does the agency still need to send out a 154 form to the prospective employee in order to complete the 152 form? This is an MHL form?
Yeah, those are the MHL 1634 check that OPWDD is responsible for doing. And I've gotten some emails recently, there might be changing the forms, and I just direct people to OPWDD. So sorry, we're not really familiar with those checks.
Okay, thank you. I suspected that. How or why would someone get removed from the staff exclusion list, the SEL?
Well, somebody could challenge the hearing determination in court in an Article 78 proceeding, and a judicial proceeding might disagree with the Justice Center finding and order that that individual be removed. After a hearing, at the regular hearing level, at where the Justice Center's administrative law judge could also determine that the level didn't rise for the preponderance of evidence for substantiation and reverse the findings. Somebody could die, and that has happened, and they're removed from the staff exclusion list. So those are three, I think, that cover basically how somebody would be removed from the staff exclusion list.
Thank you. Do we, and we probably don't because we don't handle it, but do we have any ideas on the numbers of criminal background checks for OASAS?
Unfortunately, we don't cover those. Those are a separate background check under a separate enabling statute under the mental hygiene law. So unfortunately, we don't have those figures.
Okay. And the last question before we go on, does the CBC catch people who are currently on federal probation? Does it pick up on that?
It really depends. There generally is not a subset of the FBI identification information record that specifically advises whether or not somebody is on federal probation. Generally, what will happen is there'll be a conviction from the United States District Court, and we will be able to capture that information for our review and our determination process by seeing that there was a conviction in the United States District Court.
Okay,
But
thank you.
specifically break it out to whether or not somebody's on federal probation, where, you know, the FBI identification record does not do that.
Okay, great. Carry on.
Thank you. So an interesting distinction in the law is who is required to undergo a staff exclusion list and a criminal background list check. The law requires that applicants for employment or volunteer service that have regular and substantial contact with individuals receiving services be subject to a staff exclusion list check. But the standard for a criminal background check is applicants for employment that would have, or volunteer service that would have regular and substantial unsupervised and unrestricted contact with individuals receiving services. And unsupervised contact is not permitted until the results of the checks are received. So who may request a check? The provider agency must designate a person, an authorized person, to conduct these checks. And you designate an authorized person by using our authorized person designation form, which is on our website. There's a separate one for SEL authorized persons and CBC authorized persons. So to designate an authorized person for the staff exclusion list check, you complete the form, sign it. The director of the provider agency must sign it. You return it to the Justice Center. And basically within 1 to 2 business days after submission, that authorized person will receive an email with a link to the staff exclusion online web form. Sometimes there's a new provider, we receive an authorized person form, but the provider hasn't made it into our VPCR system yet because it's awaiting uploading from the relevant state oversight agency. So that doesn't happen very often, but it could delay the granting of access after you submit the AP form. For the authorized person, as I said before, will receive an email with the link, and there's a guidance in the email that the authorized person receives. There's also a link to the job aid for conducting staff exclusion list checks. They're pretty easy to do. For designating an authorized person for the criminal background check system, there's a separate form, and this one has to be notarized in addition to being signed by the director of the provider agency. And you, same thing, submit it to the Justice Centers, the email address or the fax numbers on the form, and a few days after submission of the form, the authorized person receives an email with a link to the system. And credentials, you'll have a login and a temporary user ID and password, and that email will also provide a user guide for utilizing the CBC system. I happen to know that the staff that handle the CBC and the CBC SEL shared mailboxes are quite responsive, and we get a lot of questions. That's basically your best way to go if you have a question about conducting staff exclusion list checks or criminal background checks. We do like to know if the authorized person to keep those records updated. Oftentimes a provider or an authorized person leaves employment, and sometimes providers forget to update our system. But there is an authorized person revocation form for each SEL and CBC. Please strive to submit that so our records are accurate and who's an authorized person. And there's a link to our revocation form, and usually it's completed. The revocation is effectuated within 1 day of receiving the form. All right, some more about the staff exclusion list check. As I mentioned earlier, the staff exclusion list check must be completed prior to registering for fingerprinting. In fact, when you are registering for fingerprinting, there is a certification that the authorized person checks off saying that they have, in fact, done the staff exclusion list check prior to registering an applicant for fingerprinting. So, to check the staff exclusion list, I mentioned earlier, it's quite easy. Once you're an authorized person, you click on the web form link and you enter the applicant's name, date of birth if you have it, and the social security number. To do an online check, you do need the social security number or an alien registration number. And you certify the information after you've entered it and hit submit, and almost instantaneously you receive a response saying the person is not on the staff exclusion list. And if it's an OPWDD provider, you also get an indication of whether they have a final category 2 finding. And a lot of providers have programs under different state oversight agencies like OPW, OMH, and OCFS. And we tell providers in those categories that if you're submitting an applicant for employment and you're not sure if they're going to be solely in an OPWDD or solely in an OMH program, that you should check the providers as when you enter into to do the SEL check. You'll have each of your providers under a state oversight agency listed. Like if I'm part of People Inc. and People Inc. has OMH and OPW, when you're in there, you'd select OPWDD if your person might be working in an OPWDD program, because then you would get the additional notification about category 2 findings. But if the person will not be in an OPWDD program whatsoever, then you select whatever state oversight agency, the program that the person will be under. And again, if you have any questions, the SEL check email address is very helpful and responsive. So as I mentioned, the online checks require the Social Security number. And if some individuals don't have a Social Security number, they can do a manual check with the form. I'm sorry, I can't see is there a question at the bottom?
Don't worry about that. There is a question. I got it, Deirdre, though. You can keep on. When you get to the break, I'll ask it.
Okay, no, I'm just saying on the bottom of the screen of the PowerPoint, I don't have the full screen.
It says questions to send it to selcheck@justicecenter.ny.gov.
Thank you, Davin.
You're welcome.
All righty, moving right along. We also have the opportunity to do SEL batch checks, which come in helpful sometimes with summer employment, with camps, and you have a whole bunch of people that you're checking at once. I think we can take up to 100 applicants, and the directions are listed on this link as well, and you just put them in a spreadsheet, and then you get a response back for the batch check requests. So each online request generates a confirmation number, and you receive the response within 1 business day. And that's if you have a potential match. Sometimes it's just a common name where it might be a match. And if you don't receive it right away, it does not mean that the person is on the staff exclusion list or has a final category 2. And also, please don't continue to submit SEL check requests if you don't receive a response immediately. We get some eager authorized persons doing that. There's really no need. If you've submitted it, it will be responded to within 1 business day.
I have a question for you, Deirdre. So you went over what to do when an authorized person leaves an agency. Somebody wanted to know if there's a place that they can check to make sure that as an agency they're keeping, the list of who the authorized person is up to date.
Yes, that provider, who I would appreciate their motivations, can send a list of or a question to SEL check email address, and I'd be happy to check and let you know who all the authorized persons are. We actually do that with some of our bigger providers down in New York City with OCFS daycares and whatnot. We do a routine double checking of their lists. So feel free to send it to selcheck@justicecenter.ny.gov.
And Davin, likewise, if they have the same question regarding the authorized persons for the criminal background checks, they should send a similar email to the CBC mailbox, and we can do a check and send them a list of all the active authorized persons that they currently have.
And Laura Mandel from OMH put in the chat that OMH providers can email Laura Mandel at OMH to find out who their authorized person is. There is a question about what the manual check consists of. I think that's the double check to make sure, right?
Well, there's 2. There's the manual check when somebody doesn't have a Social Security number, and that's basically checking the name and date of birth. The date of birth is a required field for those checks. And the manual double check that we do weekly is we can run a report to see who was fingerprinted in the past week. We can also run a report to see who had SEL checks done in the past week, and we can compare them and find if somebody had a CBC without an SEL. It doesn't happen often, as a couple times, it might happen a month. And when we often find out that they just forgot to submit it and they meant to, and it just slipped through the cracks. So that's why we double check.
Thank you. That's the last question for now.
And that's a perfect timing because now we switch over to Jim to talk about CBC authorized person responsibilities.
Well, great. Thank you, Deirdre and Davin. I appreciate all the participation and look forward to all the great questions that come out of this. Davin, stop me anytime you have a question that pertains to what we're talking about. We're switching over now to authorized person responsibilities, and this is for the criminal background check system. As we discussed, as Deirdre had so eloquently discussed, to access the criminal background check system to receive criminal history information, you do have to be authorized by the provider of service as an authorized person. Okay, a quick overview of the things that we are going to discuss today. Authorized person responsibilities are to check the staff exclusion list, which we've already gone over. Provide the applicant with certain information. Register the applicant for fingerprinting. Updating employment status in the criminal background check system. Maintaining applicant records / information and ensuring that the provider has a criminal background check policy to implement the provisions of New York State law and the Justice Center regulation regarding background checks. It's just a reminder, make sure that you're submitting your SEL check. If not, we will sweep you up in the manual double check that we just talked about, and you'll get a phone call reminding you that the staff exclusion list check is a prerequisite for sending someone for fingerprinting. Okay, it is an authorized person's responsibility to provide certain information to an applicant. The authorized person must ensure that the applicant completes the applicant consent form for fingerprinting. This is a form that the Justice Center had developed that is compliant with the requirements under Executive Law 553 for a sworn statement that has to be obtained and maintained by the authorized person for an individual for whom they are going to request a criminal background check. You are not required to utilize the consent form that we provide to you. However, it, in our opinion, is the easiest way to be in compliance with the provisions of the law is to utilize the consent form that we make available to you. And you are otherwise required to provide the applicant with a personal criminal history information review form. What that is it is a form that is compliant with New York State law that requires that the provider of service give the applicant information on how they can challenge the nature of their criminal history. The personal criminal history information review form does that. It advises the applicant that has questions on their criminal background how to do a record review to challenge or to at least to review what the criminal history is reported from both New York State and from the FBI on the FBI identification record. My best piece of advice to the folks here that are authorized persons, print as many copies of the personal criminal history information review form as you care to have on hand. And anytime you interview someone and choose to register them for fingerprinting, make sure that they walk out of your office with a copy of this form, so that if on the rarest of occasions a person does have a criminal history reported against them that they believe is not accurate, they have this form and they'll be able to challenge. They'll have the tools at their disposal to challenge the criminal history information reported against them.
Jim, how long must people keep the consent form for fingerprinting and history information?
That's a great question. The Justice Center regulations state that all pre-employment material must be maintained for a period of 6 years after the person ceases to be a subject individual. So if you hire me on January 1, 2023, and you fire me by January 1, 2024, you've got to keep that information until January 1, 2030. Okay. Another authorized person responsibility is registering an applicant. One of the pieces of guidance that we like to share here is complete the fingerprint applicant information sheet. I want to reiterate here, this is not required. This is not something that you as the authorized person are required to maintain. You're not even required to use it. However, as someone that goes in and registers people for fingerprinting, it can be somewhat of a cumbersome process. You do have to enter in a lot of demographic information, contact information, things of that nature. You want to make sure that all that information that's going to go into that person's Justice Center's criminal background check record is accurate. We suggest collecting such information on the applicant information sheet. We've created that sheet and we continue to modify it so that it captures all of the information necessary for a successful registration for fingerprinting. So again, you do not have to utilize it. We suggest that you do to give yourself the best opportunity for a successful registration. You're going to register folks for fingerprinting through the Identigo website, either online or by calling the 855 number. I say at every training that I do, if somebody actually does it over the phone, I would love for them to call us up or email us at the CBC main mailbox and tell us how it went, because I've never heard of anybody actually registering for fingerprinting by calling the 855 number.
Jim, I have just a follow-up question about the fingerprinting form and history form. You said it was kept for 6 years. Is it kept for 6 years, or just for the if the person is employed for less than 6 years? Do providers still need to keep the form if they leave?
It should be maintained for a period of 6 years after the person ceases to be a subject individual. If the person never becomes a subject individual, it should be kept from 6 years after the time that the decision is made that the person does not become a subject individual.
Okay.
Or
And what if they're
does not become an employee. I apologize.
what if they're not hired again?
If they're not hired, you keep it for a period of 6 years after the decision is made not to hire them.
Okay, great. Thank you.
No problem. Okay, required applicant information for the registration process. This is a very important slide. As we discussed, there is, a fair amount of information that goes into a successful fingerprinting registration through the Identigo website. A current address, very important. Please make sure that you verify this information with your applicants prior to inputting it into the system. This address information may be utilized by the Justice Center on the back end when we have to get in touch with these folks. So it's very important that we have a verified and full valid address for that individual where they can receive mail. Demographic information, again, very important. This information is utilized to make a positive identification of the subject individual at the Identigo live scan location. If the information is off, the live scan operator will turn the person away and say, we cannot fingerprint you today because the demographic information doesn't match you. So again, this is not information that's being collected by the Justice Center or by the state of New York or Identigo for any purpose other than making a positive identification of that individual at the time they show up for the live scan appointment. Okay. Another piece of required applicant information are the specific job duties that allow you, the provider of service, to request a background check. In the job duties, this is a free text box. This is one of the few areas of the registration process where it's a free text box where you can manually enter and type in data. You must indicate the nature of the applicant's contacts with the individuals receiving service. That allows you to request a background check. So for example, if the person is going to be providing maintenance in a home and you simply write in the job duties maintenance, there is nothing in that job description that indicates how that individual will have contact with the folks receiving services in that home. A better way to do it would be to say that the person is going to be performing maintenance tasks while in the residence of individuals that are receiving services. With that job description, the folks in the CBC unit are able to know that the person is going to have regular and substantial unsupervised contact while performing maintenance duties in the residence of the folks receiving services. Okay, so it's very important to include some specificity when you're filling out that free text job duties section. And this is an example, a little bit on the nose, but this is a screenshot from the Identigo registration process where they ask for the job duties. And as we state here, the applicant will have regular and substantial unsupervised or unrestricted contact with service recipients in a direct care setting and will assist with activities of daily living. Again, you know, a bit on the nose, obviously, but it is a good example of a successful job duties reporting. The criminal background check guidance and resources section of the website will provide separate fingerprint registration guidance. And it does have identical links and service codes for OMH, OCF, and OPWDD. These are the three state agencies that we have jurisdiction over, at least in part for OCFS, for criminal background checks. If you have any question during the registration process of what the unique service code is for an OMH program versus an OCFS or OPWDD program, the Justice Center's guidance and resources section will have that information for you. And if there are further questions beyond that, if it's something that you're having a difficult time finding, don't ever hesitate to contact the CBC unit via email or phone, and we can get that information for you. And we can also provide you with information on how to more successfully find that information online. Okay, record retention rules that we've already actually touched on this in response to one of our great questions earlier. You are required to retain the applicant consent form. You're required to maintain the CBC results. We've got asterisks here because I'm going to qualify this for you, and subsequent arrest notifications. As we stated earlier in response to the question, the information above must be maintained for a period of 6 years after the subject individual is no longer employed or volunteering. We answered that question. As far as retaining CBC results and subsequent arrest notification information, we try to make that as simple as possible for you. It's actually maintained in the Justice Center's criminal background check system. So for providers that were thinking that they have to retain this information by printing it out and maintaining it in a confidential and locked file cabinet away from everybody else in the HR office that doesn't happen to be a authorized person, you don't have to do that. You will be in compliance with the record retention rules by virtue of the fact that you are an authorized person and you have access to the CBC results and the subsequent arrest notification because it is maintained in the criminal background check system. So if your state oversight agency does come out to audit you, you will be able to, within a few keystrokes, pull up the CBC results for all of your subject individuals for whom you've requested a background check. You will also be able to pull up all copies of subsequent arrest notification information. What you may have to keep confidentially are results of any sort of investigation that you've done in response to a subsequent arrest notification. But otherwise, those two pieces of information are retained in the CBC system. And my best suggestion to you in the name of confidentiality and dissemination of sensitive information is to leave it there. You can access it when you need it. Okay, one of the authorized person responsibilities, and a quite important one, is updating the employment status of individuals for whom you've requested a criminal background check. Okay, Justice Center regulations require that you update the employment status in the criminal background check system within 14 days of any change of status. Okay, we've put a screen grab here and we've intentionally highlighted applied, as you can see with the big red arrow. and the highlighting. Applied will be your default. So when you submit a subject individual for fingerprinting, when the fingerprints come back to us and the fingerprint or the subject individual's record is created in the Justice Center's criminal background check system, they will always default to applied until you, the authorized person, make a change. Okay? We'll do this by way of example. Let's say that Deirdre was going to hire me to come work at her provider of service. Again, I don't know why she would, but let's just say for the sake of this training that she would. She fingerprints me on April 1st, 2023. My results come in same day. She makes a decision the same day that she wants to hire me. She has until April 15th, 14 days later, to update the Justice Center CBC system employment status from applied, which is the default for my record, to hired as a subject individual. Let's assume that Deirdre very quickly understands that I'm a terrible employee and by the end of the month wants to get rid of me, and she terminates me on April 30th, 2023. She has got until, by my rudimentary math, May 14th, 2023, to update the CBC system, the employment status, to take my record out of hired as a subject individual and update it to no longer employed. Okay? And that is those are requirements from the Justice Center CBC regulations. There are a number of reasons why we have to have accurate or as accurate as possible information on subject individuals' employment status. For example, if you allow someone to remain in a hired status for a extended period of time after they are no longer in your employ, if we receive an arrest notification for that individual, and what we will do is go in. So if Deirdre, or if the Justice Center receives an arrest notification for me in September of 2023, after I've no longer been a subject individual for the past 4 months, she is going to get notification from the Justice Center that I was arrested, that her employee, me, that I was arrested, and essentially what she would have done is facilitated illegal secondary dissemination of that arrest information by not updating the system to notify the Justice Center that I was no longer an employee there or no longer a subject individual. So that's just one example. I could probably give you a dozen reasons why you are required to update the system and to keep an active roster of your subject individuals. But again, it is a requirement and it is an authorized person responsibility.
Jim, I have a couple questions before you move on. There's been a couple people that have asked, like, if a person has gone through maybe the OASAS criminal background check or, an OPWDD or another provider agency, and then they apply for another job, maybe they're going to work at one or more agencies, do they still have to get fingerprinted and go through the staff exclusion list check when they go to that other agency?
So we'll take this one at a time. Yes,
okay.
A staff exclusion list check must be done. Thank you, Deirdre. And yes, a new criminal background check has to be done, regardless of whether or not the previous background check was done at OASAS or it was done through the Justice Center. A new background check has to be done. Part of the reason is our use and dissemination agreement with the Division of Criminal Justice Services only allows us to utilize the results of a criminal background check for the purpose that it was intended. So if Deirdre is a provider, she does a background check for me to come work at Parsons, that result is good for that purpose. If I go across town in 6 months and I apply to work at St. Coleman's as a YDA, I cannot utilize the results from Parsons that were provided to Deirdre for that purpose. So the answer is you have to get re-fingerprinted. Criminal history record check results are living, breathing documents. They're constantly changing. They can change by the day. What we cannot do is maintain that information beyond the scope of what it was originally requested for. So
Thank you.
you will need a new background check with updated and current criminal history information contained therein.
Okay. And I have a question. If foster parents are certified because they're technically not employees, what's the recommended employment status that they should use here?
I think that any one of the employment statuses that show that the person is currently engaged in the service is sufficient. Hired as a subject individual is fine. I would suggest that for those folks that they used hired as a subject individual, while it may not technically be accurate, it may not be an accurate portrayal of what the person is doing as a certified foster care provider. It still shows us that the person is active. And if there is an arrest, it will prompt us to notify the requesting provider of the arrest.
Right.
Thank you.
If I can just interrupt, I was going to mention before the questions, Davin, as far as staff exclusion list check, in addition to the criminal background check being a living, breathing thing, staff exclusion list check status can change daily. You know, you could be, if they're involved in a hearing, it could be removed, or they could just be placed after you've got a check done 6 months ago. And another reason to update the CBC's employment status is we check that when there's an addition to the staff exclusion list check to see if a provider has hired somebody in a hired status and they get on the staff exclusion list by working at another provider, and they've done a staff exclusion list check on that person, we look into the CBC system to see their employment status to see whether we should send a notification about the subsequent staff exclusion list placement. Very important to update the CBC system.
Yep. And it's an easy check for the staff exclusion list. In the event that the employment status is not updated within the proper time frames and an authorized person ends up receiving information about an individual, do they have any reporting or notification requirements to take in that case?
No, we would just ask that they go in and update the system as soon as possible.
Okay. And this is my last interruption for the time being. There was a question about, if clean slate is passed, how that would impact CBC. We are not going to answer questions about legislation that hasn't passed because it hasn't passed yet. So we can't specifically know exactly what the impacts will be because, legislation does nothing but change until it gets completely passed by the legislature. So please don't ask those questions. We're not going to be able to answer them to your satisfaction. I'm going to go off video now. Continue, Jim.
Thank you, Davin. Moving on. Authorized person's responsibility, or the actual responsibility of the provider, is to ensure that it has a policy to implement the regulation. So the New York State law says that each provider shall have a policy designed to implement the provisions of the Justice Center's criminal background check regulation. So if your state oversight agency comes out, they may ask to see your criminal background check /SCL /Justice Center, whatever you want to call it, policy, to ensure that the provider of service is taking the appropriate and statutorily required risk management steps of doing the pre-employment checks. Again, this is not something that the Justice Center is going to check on, but your state oversight agency, in doing its analysis of your compliance, may come out and ask you to see a copy of your criminal background check policies and procedures. What we have done is we've created a draft sample policy. It really is tailored very closely to the regulations. We understand that it's not a one size fits all. You can't simply pull this up while the auditor's in your office and plug your name in at the top and say, this is my policy. I think that'd be pretty transparent. But we do think that it is a good place for each provider service to start when they're crafting their own policy, whether it's part of your onboarding, part of your offboarding policies and practices. It is your responsibility as an authorized person to have a policy in place to implement the regulations.
Quick question, Jim. If
Sure.
someone is put on administrative leave, for whatever reason, does the person have to go in and change? Does the authorized person have to change their status to, hired or back? I mean, if they're on administrative leave is what's happening.
We have included at the request of the provider community an administrative leave option on the in the Justice Center CBC records. That being said, you don't have to use it. Use it if you'd like to. We understand it to mean that the person is still in your employ as an active subject individual. The real result is whether or not you will get arrest notifications that come in for that individual. And if, our staff has been instructed, if an arrest notification comes in and somebody has been placed in administrative leave, that they are active and to send the arrest notification. So it's one of the rare instances where you can choose to do what you want. I think if you leave them in hired status, it is essentially the same thing. We're going to move right on to the exciting topic of criminal background check determinations. So let's jump right into it. We're going to be talking about the types of criminal background checks determinations, not denied, held in abeyance, denied. Jump right into the not denied. Okay, two types of determinations that you are going to see. We'll get into some numbers, hearkening back to our CBC 2022 determination slide. Non-ident, no criminal history, and not denied, no criminal history. These are indications that a person has either never been fingerprinted or has been fingerprinted but has no reportable criminal history. In either scenario, the applicant may be considered for employment after you receive these results. If you recall, in 2022, we fingerprinted just over 100,000 people between OCFS, OMH, and OPWDD. About 88,000 people came through as either a non-ident, as not denied non-ident or not denied no criminal history. These numbers, about 87 to 88% of the people that we fingerprint annually, these numbers are extraordinarily static, so much so that it's actually hard to believe over the past 18 years that I've been doing criminal background checks. So when you submit somebody for fingerprinting, 8 plus out of 10 people are going to come back as one of these two things: not denied non-ident, not denied no criminal history. So again, for most providers out there, the majority of the folks are going to be from slide 41 from the Justice Center CBC training. Now, you may have somebody come back with a CBC determination of not denied criminal history. Okay. If that is the case, the New York State criminal history will be shared with you, and the applicant may be considered for employment. What you will not see, and what we cannot or we're prohibited from sharing with you, is criminal history from outside New York State. That includes criminal history from United States District Court, regardless of what state it sits in, i.e., if you have an individual who is convicted in Southern District of New York of a crime, we are not able to share that with you. Very quickly, this is the result of a FBI civil fingerprinting audit of all state fingerprinting processes back in 2011, if I'm recalling correctly. It was determined that secondary sharing of information from the FBI identification records was prohibited. If we did choose to share it, we run the risk of no longer getting criminal history information from the FBI and thus being unable to fulfill our obligations under New York state law. What I will say is that the Justice Center's criminal background check unit has access to the entirety of the person's criminal history, and we do take into consideration in our required analysis under New York State corrections law all convictions that occurred, whether in New York State or outside of New York State. So I don't know if that makes anybody taking this training feel any better, but there is a required analysis under New York State corrections law, and all convictions, and charges, anything on an FBI identification record, regardless of the fact that we can't share it with you, is being considered and taken into account when we're making determinations on suitability for employment. Long story short, you receive a criminal history and the determination is not denied criminal history, you may consider that individual for employment. Something that we don't really see very often anymore is the determination of not denied with an insufficient court supplied information. Recent changes, and I guess by the term recent, I mean within the last 3 years, recent legislation passed in New York State allows the Division of Criminal Justice Service, or requires, the Criminal Justice Service to suppress certain types of criminal charges that are showing up on rap sheets. I think it's a recognition that in a lot of circumstances, there are courts in the state that are not successfully reporting disposition of criminal matters. So what we used to see quite often were rap sheets that came through with information that just was not accurate. An example would be, and I hate to pick on them, and I do this every single time I have one of these trainings, are, felony offenses where the indictment occurred in Monroe County. We used to see felony charges that occurred out in Monroe County. They were no longer valid. They did not result in a criminal conviction. The dispositions were not reported. We would see those. We had a choice at one point as to whether or not we held the application in abeyance because the charge was showing on the rap sheet, or not reporting it at all without having that disposition. The compromise that we made, which we felt was in the best interest of everybody involved, was to report the charges that we could not perfect, let the provider know that these charges were on the rap sheet, but that we were unsuccessful in our efforts to obtain a disposition. What we tell the provider if you receive this is, okay, the person had a grand larceny charge from 1997 in the Monroe County Court. The court failed to provide a disposition. This is on the person's rap sheet. However, you may consider this individual for employment. We're not going to hold up an otherwise promising employment candidate because of something that the court failed to do in reported disposition. So that's really the genesis of this. Since the legislation that I previously alluded to has passed, it is really significantly cut down on the amount of times that we actually have to do this. So I think for the providers out there, it'll be very rare that you actually see a determination of this type. Okay. Moving on. Determination of not denied, not held in abeyance. Okay. An individual's come through, frequently we see this, with a pending criminal charge. Person goes out and they get themselves arrested for petty larceny. And use that as an example. A week later, while the charge is still pending in the Bronx criminal court, they get fingerprinted. The rap sheet comes back and shows that they were arrested and charged with petty larceny, that the charge is open. In an instance like that, we have discretion, and we'll talk about this in a few slides. We have discretion to still clear the individual for the provider's consideration for employment when the pending charge is for a misdemeanor offense. We go through our Article 23 analysis. If we determine that there is no direct relationship between the charge and the position of employment that the person seeks, we will go ahead and issue a clearance and allow you to consider that individual for employment. The determination that you will see is not denied, not held in abeyance, and the pending criminal charge will be reported to you. Now, where there's the not hold in abeyance, there's also the hold in abeyance. Okay? Held in abeyance. If the individual has a pending felony offense, okay, if you change that fact pattern that we just discussed to the person not being charged with petty larceny, but being charged with grand larceny third, That is a felony offense. If we have a rap sheet that comes through on a subject individual and the person has a pending felony from last week for grand larceny, we are required under New York state law to hold that application in abeyance pending the outcome of the felony offense. Okay? Now, if the person's, let's change the fact pattern slightly. If the person is fingerprinted and the rap sheet comes through and the pending charge is for criminal obstruction of breathing or blood circulation, and the second pending charge is for acting in a manner to injure a child, those are misdemeanor offenses. We have the discretion under New York state law to hold the applicant in abeyance pending the outcome of misdemeanor charges. Okay? If you receive a determination that the applicant is held in abeyance, that individual cannot be hired in that direct care position. Okay? And we're going to talk about this a little bit more going forward. Okay? Hiring decisions and pending charges. When you receive a determination that an applicant is held in abeyance, it does not mean that you have to automatically move on from that candidate and find someone else. You, as the authorized person, still have the right to consider that individual potentially for employment. Okay? However, we have to get a court disposition and make a final determination on suitability for employment before you could bring that person in and allow them to have the statutory level of contact with the folks receiving services at the provider. So, should you choose to continue considering that individual that's been held in abeyance, what you, the authorized person, have to do is work with that individual and let them know that prior to you moving forward, potentially moving forward in the employment process, is you have to get a court disposition. So in the instance where that grand larceny charge was pending, maybe the person tells you, yeah, I was arrested, I was arraigned on these charges, but the district attorney guarantees me in 2 weeks at my next appearance, they're going to drop it down to a petit larceny and I'm going to plead to it. I can use any example, really. What you may want to do, because that's a nonviolent felony offense, is, this person on paper may otherwise be a great candidate for employment. What you're going to want to do is instruct that person that when they do go to court and when they do accept that plea, whatever it may be, to make sure that they demand that the court provide them with a certificate of disposition, an original copy certificate of disposition indicating what the disposition of that pending felony charges or those pending misdemeanor charges are. Once that person has that, they should be instructed to provide it to you, the authorized person. You transmit it to us. It can be sent as per the instructions on the hold in abeyance letter to the Justice Center's criminal background check unit directly. Once we receive that disposition, we can change what the criminal history is and we can make a determination on suitability for employment. So in the example of your great candidate with the grand larceny charge, let's say a month later they go in, they take a plea to petit larceny, they have that certificate of disposition indicating such, they send it to you, you get it to us, we're going to see it, we're going to go in, we're going to change that determination from held in abeyance with a felony to not denied with a criminal history, and we are going to report back to you exactly what you know, that the person's been convicted of petit larceny and that they are now being changed to not denied with a criminal history. A lot of times what happens is that the charges get dismissed, the person goes in, obtains that certificate of disposition, they communicate that to the provider of service, i.e. you send it to us, we get the person cleared same day. But it is very important that if you are going to move forward, if you would like to move forward with these individuals for whom you've received a held in abeyance determination, that you work with them to get a certified court disposition into our hands so that we can make that determination in a timely fashion.
Jim, I have a couple questions for you.
Devin, could we hold off 1 second just so I can get
Okay.
to the second bullet? I appreciate it.
Okay, yep.
Conversely, if you receive a determination of held in abeyance and you do not want to move forward, We do ask that as soon as possible after you choose not to move forward with that individual, that you update the employment status in the Justice Center CBC system to application withdrawn. It's pretty simple. Davin, yes.
Sorry, Jim.
Okay.
So I think this person would appreciate this clarity. This person was told that they're not supposed to do background checks until the first day of employment. So the person wanted to know if they're supposed to do background checks, staff exclusion list checks before they are hired.
What I can tell you is, and I don't want to get too far into the weeds on individual employment practices. What I can tell you is that you cannot allow an individual to have regular and substantial contact with folks receiving services without an SEL check. Likewise, you cannot allow anybody to have regular and substantial unsupervised or unrestricted contact without a Justice Center's criminal background check determination. You should craft your employment policies as such without, again, speculating too much. I do understand that there are laws out there that indicate that a conditional offer of employment must be made prior to requesting any information about a person's criminal history. You know, that is in New York state law, and you should craft your employment or your pre-employment policies accordingly. But when you say that you have to start the person's employment prior to requesting this information, I would check with your own counsel before proceeding in such a fashion, because I don't think it's accurate.
Okay. Thank you. And if you did hire somebody who was held in abeyance and you put them in a position where they had no contact with people receiving services, and then can the employer terminate that person after the outcome of the being held in abeyance comes out?
If you've received a result from us that is adverse to the person's employment and you choose to utilize them in a position that does not require a background check, i.e., the position does not involve regular and substantial unsupervised unrestricted contact, you kind of take it out of our jurisdiction and you put it into your own. I would say there, again, you would certainly want to confer with your own executive team and your own counsel to determine what's appropriate as far as termination of a person that you've hired.
Okay. Couple quick things. OCFS notes that they require all checks to be completed prior to the date of hiring, including before training. And then people want to know about how to submit court disposition to the CBC unit. Do they use a CBC email address?
Because the law states that we need certified court dispositions, our preference is to have you stick it in an envelope and send it to our post office box so that we can actually have our hands on and certify that the document is real. So that's what we instruct in the letters to the provider when we do hold somebody in abeyance. Now, that being said, if you're in an emergency situation and staffing requirements dictate that you have somebody immediately, we would certainly accept a copy sent via email, but something that we can verify with the court is legitimate. So the best way to do it is to follow the instructions in the letter we provide to you and send it to us to our post office. But we will accept, in a case-by-case basis, we will accept these via email so long as they are followed up with a mailing so that we actually have a certified copy of that disposition that we can hang our hat on, so to speak, and we know that we have a good disposition.
Thank you.
Okay, great. Moving on. Okay, denials. As we saw from the earlier slide, 100,000 plus people were fingerprinted in 2022. My recollection is that we denied a total of 291 people. So for the mathematicians out there, if you could come up with the percentage of the people that we denied in 2022, I'd appreciate it. It's probably about 1/3 of 1% of the people were actually denied. So The vast majority of the participants here that are authorized persons have probably never actually seen a denial, since we do so few of them. However, if you do receive a notification that an applicant has been denied by the Justice Center, you may not hire that person in the direct care position for which the criminal background check was requested. Okay? You will obviously be notified of the determination via a correspondence uploaded into the CBC system. So we are going to notify you of the nature of the criminal history and the fact that the person has been denied employment. Once that does happen, there are some enhanced roles that the provider plays here. And these are things straight out of New York state law that are required of the provider of service when you do receive and notice that one of your subject individuals has been denied employment. You, the provider of service, are required to notify the applicant that the employment was denied and that the criminal history was the basis of the denial. That is, again, in New York state law. That's not a Justice Center requirement. The practical reason for that is that when the state of New York does make an adverse determination and denies somebody employment, we've taken away a property right, and they retain the right to challenge our determination as arbitrary and capricious and abuse of our discretion. The only way they can do that is by being notified that they were denied. Okay? So you have to make that notification. It should be done in writing so that the statute of limitations on their ability to challenge our determination can start running. A few years back, we were notified by some of the advocacy groups in downstate New York that providers of service were having applicants that were denied, and they weren't bothering to follow up with them. So people were left in limbo. They either submitted information, at the very least, they went and got fingerprinted for a job that no one ever followed up with them for. So as a courtesy, the Justice Center implemented a policy that when we do issue a denial, we notify the individual that they were denied and that the criminal history was the basis of the denial. That does not relieve you, the provider of service, of your obligation to also notify them. We felt that in the event that a provider was shirking their responsibilities there, we would rather have the person know from us that they were denied and then allow them the opportunity to decide whether or not they want to challenge our determination under the State Administrative Procedure Act rules. So while we do this as a courtesy, it does not relieve you, the authorized person, of your obligation to notify them. The provider must also furnish a copy of the reported criminal history summary upon written request from the applicant. I don't know how often that actually happens. I think, quite frankly, the applicants request that more from us than they do of the actual provider of service. Since in this instance, we were the ones who denied them, it makes sense that they contact us and ask for the information. However, if the subject individual does approach you and requests in writing a copy of the reported criminal history summary, you should provide that to them. No questions on denials, Davin?
No questions.
Excellent. Okay. Buckle up, everybody. We are about to discuss the most difficult topics I think that we're going to discuss today. I don't want to speak for Deirdre, but in the criminal history world, your status updates always generate the most questions from the provider community. None more so than the mysterious status update from the CBC system of none being processed. Okay? You have an applicant that goes and gets fingerprinted. The results come in. Their status change is from applied to none being processed. We are going to explain to you what this means. Hopefully, it will cut down on the amount of emails that the CBC unit gets that say, and I quote, "My applicant is none being processed. Can I hire this person anyway?" So let's jump right into it. Okay. The authorized person's role. if you receive a notification, a status update that your individual that went for fingerprinting is none being processed, it means that we have not yet made a determination on the applicant's suitability for employment. You may not hire the applicant at this point in time. You may only move forward with a hiring decision if and when a determination has been issued for this applicant. So for the duration of the time that the person is none being processed, we have not made a decision. You, the authorized person, cannot move forward. Hopefully, we're going to cut down on dozens of emails just from that statement here today. There are two scenarios in which the Justice Center will update a subject individual status to none being processed. Okay? Scenario one happens about 1% of the time. So we might as well spend some time on it. If you receive a notification that somebody is none being processed, it could mean that the applicant's criminal history record includes a criminal charge for which the CBC unit cannot determine the disposition, and we have reached out to the applicant to provide disposition information on the charges. Okay? What we've done in this scenario is said, we see that there's a criminal history, most likely something outside of New York State. We don't know what the disposition is. We are not comfortable issuing an insufficient court-supplied information clearance. We are reaching out to the applicant to provide disposition information. Recent example of such, I think we had a rap sheet come in and it showed a charge out of Illinois for indecent dissemination or dissemination of indecent material to a minor. Obviously, that is a charge that is in the category of sexual offenses. The disposition was not reported on the record. If there was one, we are clearly not going to allow you to cut that person loose, providing care to individuals in a direct care setting. What we did in that scenario was we reached out directly to the applicant, provided the information, and told them that they had to provide disposition information to us or we would not be able to move forward in the employment process. The first thing we did was update that record to none being processed. Okay? I think in the previous full year of 2022, we had to do this 12 times. So it is not often that this happens. We made it scenario number one here in the none being processed world because it doesn't happen very often. So the potential results of the none being processed, not denied is most common. None being processed, disposition received, the process can continue, see number two. Moving on, none being processed status update. The most common scenario is the CBC unit is considering directing the provider to deny employment based on the applicant's criminal history, and we are requesting evidence of rehabilitation directly from the applicant. What could happen from there is a denial, a clearance, or the second status update that we're going to talk about in the brief time that I have left, criminal history, okay? If you receive a result that just says criminal history, and I shouldn't say result, I apologize. If you receive a status update that just says criminal history, this is an indication this is not a final determination. This is not a not denied criminal history. This is just us notifying you that the person has a criminal history. And I'm going to try to go through this as quickly as possible. When we are considering someone for a possible denial of employment, New York state law requires that prior to doing so, we request evidence of rehabilitation and good conduct from the applicant. That is done by sending a letter to the applicant via United States Postal Service certified mail, which allows us to positively track the delivery status of that letter, okay? There are scenarios where the letter simply doesn't get delivered. It's unclaimed or undeliverable. We cannot confirm successful delivery of that letter to the applicant. What is the practical result of that? We are now unable to sufficiently state that the person has had the ability to provide evidence of rehabilitation and good conduct for our review prior to us making a determination. Okay. So when the letter comes back as unclaimed or undeliverable, we go to this process. Okay. We first update the JCCBC system to say the status update criminal history. Okay. When we do that, we will notify the authorized person via email that the letter was unclaimed or undeliverable, that the background check process cannot continue pending action by the authorized person. Okay. The email will contain notice that a criminal history summary was uploaded to the CBC system for review by the AP, and it will give you instructions, explicit instructions, if you wish for the process to continue, and instructions for resending the letter. Okay. To the authorized person, when they receive this status update of criminal history, they're going to get bombarded with 2 emails. The one we just discussed. They'll also get an auto-generated email from the system of an update to the record. If you receive this, you are also on the Justice Center CBC record going to get a criminal history summary. Okay? If you wish to continue with the pre-employment process, this is what you must do. You must advise the criminal background check unit via email that 1, you have reviewed the criminal history that's been uploaded to the CBC system. We'll know whether or not you reviewed it because the records are all timestamped. Okay. You're going to tell us 1, that you reviewed the criminal history, 2, that you remain interested in hiring the applicant. Okay. You will provide a verified address. Even if it is the same address, you're going to have to verify that the address is accurate. And then you're going to have to request that the letter be resent. If none of those things happen and you are not interested in hiring that individual, please go in and update the record to say that they're not hired. However, if after review of the criminal history, after you receive these updates, you want to move forward, you have to respond according to the instructions on the email and according to the instructions that are reiterated to you on the letter that's uploaded to the CBC system. Okay. And I do apologize. We are a little bit rushed here. I do generally spend a heck of a lot more time on this status update than I am able to here. If there are any questions, please don't hesitate to reach out directly to us and we'll be able to answer these questions or provide any information that covers the gaps that I may have missed here in being pressed for time. As I stated, the authorized person should update the employment status to not hired if you receive this status update and you don't want to move forward. Failure to update the employment status, the person may remain in an applied status indefinitely. In that scenario, when we do uncover those, we do advise your state oversight agency of potential instances of noncompliance. They may call you, they may reach out to you and say, what have you done with this individual? That person was never cleared for your employment. Hopefully you haven't hired them, but we're going to go ahead and let the state oversight agency know of potential instances of noncompliance when you fail to update the system. Subsequent arrests, very quickly. The Justice Center receives arrest notifications for individuals that have had a criminal background check through us. As you can imagine, we receive a lot of them. When we do receive them, the New York State law requires that we notify the provider of service that that the hired subject individual has been arrested. The provider of service shall take any and all steps that they deem necessary to protect the health, safety, and welfare of individuals receiving service upon receipt of a notification that your employee has been arrested. We do ask that if you receive an arrest notification, as we stated earlier, and the person is no longer in your employ, please disregard the arrest notification and immediately update the record to no longer employed. But if you do receive an arrest notice for an individual that is in your employ, the only guidance that we can give you is exactly what the statute says, and that is that you have to take any and all steps that you deem necessary to protect the health, safety, and welfare of the folks receiving services.
Jim, quick question. What's the difference between application withdrawn and not hired as subject individual?
None. Both are deactivating the person as an active subject individual. So there really is no difference. If the person was employed and you inadvertently put application withdrawn, we're not going to pull any negative inferences from that. You may wish to contact your state oversight agency so that there's no confusion when they're doing their desk audits. But from the Justice Center's vantage point, it really means the same thing.
We have 1 minute left, Jim. Sorry.
All right. Applied statuses and arrest notifications. The provider will not receive arrest notifications when an individual that you have fingerprinted remains in applied status for 3 months or more. We cannot justify sending an arrest notice for somebody that has remained in that status for that period of time. You will receive emails, phone calls from the folks in the CBC unit asking for an update on that status when there is an arrest. You want to make sure that you have an active roster of subject individuals that are responsive to such requests from the Justice Center, because you do not want to compound an error in failing to update with not getting back to the Justice Center and having us sit on a potentially dangerous arrest notification on an employee of yours. So don't compound your error by not getting back to us in a timely fashion to notify us of the person's employment status.
I see that contact information has been put into the chat. I think, because it's in the interest of time, I think, and this PowerPoint will be available on the website. And if you have burning questions, this is the best way to get them addressed. And, Jim, as you know, Jim and both Deirdre and Jim know a lot, and they will give you as much information as they can.
Maybe more than you want.
Probably.
I pulled up, as Davin was saying that, I pulled up the contact information. We really only missed out on one section. And if anybody has questions about the potential of temporarily hiring individuals during the criminal background check process, email our office with the question. We will get back to you as soon as possible. And I'm terribly sorry we didn't get to that today.
Yeah. And one last thing, anybody who's interested in online training, check the Justice Center website all the time. We have a training link. You'll see it. Really easy to sign up for any of the online trainings that we offer. So thanks, everyone. Thanks, Jim. Thanks, Deirdre.
Thank you very much. Have a great afternoon.